on transnational litigation to protect human rights. The event is part of the Human Rights in Practice series that is run by the Clinic and the Centre for International Comparative Law. And today we're really very privileged to have two speakers joining us in person to really reflect upon their own experience in engaging in often quite long-term transnational litigation for the purpose of protecting and ensuring human rights, including of marginalised people. So we're going to be, in terms of the format for today's event, we're going to hear from each speaker for a short period of time, and then we'll open up to a Q&A. And so I really encourage you to really be thinking through like the questions you have around what function litigation plays, including in contexts where you have courts that, for example, support the executive function or who are not willing to enact human rights protections. And so please I invite you to really engage with our experienced speakers on these questions that you might have around what is the role of litigation, right, in these moments in securing rights protections, including in times of crisis. And so just to take a step back, we have, I mentioned, two speakers here. We have Thomas Becker, who is a legal and policy director and senior clinical supervisor at the University Network on Human Rights. Welcome, Thomas. And Katie Gallagher, who is senior staff attorney for the Center for Constitutional Rights, CCR, based in New York. Okay. And I should just mention before we open the floor to our speakers that today's event is co-sponsored by a number of entities at the law school and on campus, including the ACLU, American Constitution Society, the Duke Human Rights Center at the Franklin Humanities Institute, Human Rights Law Society, International Law Society, and the National Lawyers Guild. Okay. So with that in mind, again, I'm inviting our speakers to take the floor, and then we'll open up for a more interactive Q&A to get more into the issues. So thank you, Thomas.
Perfect, thank you. And thank you all for coming. Thanks for organizing. Thanks, Katie. In my world, Katie's a total rock star in the litigation world, so it's a treat to get to share in this panel with her. So I'm going to jump right in because I'm very conscious of these lunchtime events bleeding into class quite quickly, so I'm just going to dive right in. And I'm going to approach this less as a lecture. Boy, my students have to hear me lecture all the time. And so I hope this can be a conversation. I hope you all have questions. I hope you engage. I think we can all learn from each other. So please, I want to treat this like a conversation with you all. So I'm going to talk about transnational litigation through the lens of the Black October cases that I'd worked on. One was in Bolivia at the Bolivian Supreme Court, and another was in the U.S., a civil lawsuit against the ex-president of Bolivia that we brought and litigated for many more years than I would like to think. And, over the next hour, I'll talk about the nuances and the slight differences and the way they've reinforced each other. But what I want to start with is to kind of zoom into the way litigation can be used to really move the needle, regardless of the outcome of a case. I think that often in law school, the success is treated as a binary. If you win the case, it's successful. If you lose the case, it's not successful. And I think that's a real mistake. And particularly in the cases we worked on Bolivia, we knew they were uphill battles, and we tried to frame them in a way where, regardless of whether we win or not, we are going to win. And we were very intentional about the different steps we took to make that materialize. So before diving into all that, I'm assuming most of you are not up to date on Bolivian politics. I've been, working in Bolivia for the last 20 years, and I'm barely up to date. So I'm going to give you the Cliff Notes version of Black October in Bolivia. It's very cursory, very quick. I apologize. It's offensively quick, but enough that we can at least have a conversation about this. So Bolivia is the most indigenous country in the Americas. Roughly 2/3 of the country identifies as indigenous. Despite the overwhelming indigenous majority, it has been exclusively run by what they would say is gringos, white people, people of European ancestry, since the Spanish came. And this changed in 2003. 2003, Black October was kind of this revolutionary moment in Bolivians' history. All sorts of changes in terms of indigenous power, control of resources. Black October changed. During Black October, a guy named Gonzalo Sanchez de Lozada, Goni, was the president. He was known as El Gringo, the Gringo, in part because of his accent. His thick American accent was somehow worse than my Gringo accent, and my Gringo accent's quite bad, unfortunately. But mostly because he grew up in the United States. His family was associated with a lot of the economic and political elites of the United States, the robber baron families, from years and years ago. And he was educated at the University of Chicago at this peak time when Milton Friedman was there and the Chicago School of Economics was really blowing up. So he was influenced by this. He moved down to Bolivia, and when he became president, he privatized most of the industries in the country. It was absolute disaster for working people, particularly indigenous. It was a total fire sale of the industries that was sold to the global north, to the United States and Europe, or at least our corporations. And so Bolivians thought, look, this is a continuation of colonialism. And they went to the streets and protested. Instead of engaging the protesters, he sent the military and gunned them down. And children as young as 5 were killed by soldiers. Following the killings, he fled to the United States and has lived here ever since. He lives in D.C. right now and has received protection by the U.S. government. I've been fortunate to work with the families of Black October for the last, now 2 decades, 20 years. And look, initially we were trying to extradite Goni back to Bolivia to face trial there. And it was very clear that that was not going to happen. Again, he was an ally of the U.S. He sold us gas and other things quite cheap. And so he was protected. And the U.S. just ignored extradition requests. So with the families, we started exploring, okay, how do we hold him accountable? If he's not going to come back to Bolivia, what are our options? And, I mentioned this because you never know in law school these things that end up sticking with you. And I took this course in my first year of law school where I learned about this thing. And this was just in passing. We were talking about other things, but the Alien Tort Statute and the Torture Victim Protection Act, these 2 mechanisms to go after human rights abusers in the United States, even if these actions take place somewhere else. And it kind of stuck. At the time, I thought, wow, I wonder if we can do this in Bolivia. So between my 1L and 2L year, I returned to Bolivia. And with the families, we started exploring, okay, if Goni's not going to come back here, maybe we go to the U.S. to hold him accountable. And we started looking at, okay, how can we litigate? How can we use litigation to move the needle, to get some form of justice for the families? When we first started talking about it, I got to be honest, people thought we were crazy. Goni is one of the richest, most powerful people in the history of the country. He's intocable, untouchable. And these are Aymara campesinos, peasant Aymaras. I'm a 1L. I know virtually nothing about law at this point. And it's debatable if I do even now, but it's certainly not as between my 1L and 2L summer. And the Bolivian activists and lawyers we were working with also, they didn't know much about the U.S. legal system. And nobody had also brought in a case against a living ex-president for human rights violations ever in the United States. It had never been done. It was objectively kind of ridiculous. But the more we talked about it, the more we saw these avenues for real social change. Despite it being an uphill battle, we saw we had other goals other than just, and our goal was to win this case, certainly. But we created these other goals because we thought we can use this litigation to move the needle, to get some form of justice, to push legislation. So when we started crafting this case, we had 3 goals in mind besides winning the case. The first was we wanted to legitimize the voice of the family members. Bolivia is incredibly racist still. The indigenous are treated in many ways as second-class citizens, and there was a large sector of the population that simply did not believe the narrative that the families were victims. They believed Goni's narrative, that they shot themselves, that they were guerrillas, they were communist terrorists, et cetera, et cetera. And the second we filed this in U.S. court, and this is very problematic, I think it's very colonialist that we have to file in a U.S. court to give legitimacy to indigenous communities. But it did give legitimacy to them. It gave them a platform that they simply did not have before. All of a sudden, it was in a U.S. courtroom. These things that they were saying in Bolivia were being said in a U.S. courtroom. It gave them legitimacy. It also served as a catalyst for a trial that we brought in, the trial of responsibilities in Bolivia. So because of the nature of these human rights abuses, you don't bring a normal criminal trial in Bolivia. If state officials are involved in abuses, you have to bring what's called a juicio de responsabilidades, a trial of responsibilities. It's basically like it'd be like an impeachment trial with criminal penalties. But in order to bring these cases, a trial of responsibilities in Bolivia, you need a 2/3 approval of the legislature. We did not have that at the time. Many of the legislators were allies of Goni. Many just wanted this to go away. It was just, they could be held accountable if these things move forward. So they did not want this to move forward. But the moment we filed this in the United States, it made it really hard for them to just kind of look the other way. It became international. It became something that, look, if a U.S. court found enough, there's enough evidence that we survived a motion to dismiss, this is maybe something we're going to have to accept and move forward with. So it, in many ways, became the catalyst for a lawsuit or for a criminal trial in Bolivia that we worked on for several years. And still to this day, there are generals in jail for genocide because of this trial that in many ways, the civil lawsuit in the United States, the litigation in the United States, triggered in Bolivia. A second goal we had was to shame Goni. I don't know if any folks are familiar with Escrache in Argentina, but to really just out him for what he did. He came to the United States and was living in his mansion like nothing had happened. And that was not okay for Bolivians. And we knew that bringing a case against the next president would get us some media attention. I mean, most of the coverage when this initially happened was quite favorable to Goni. That Goni fled in the midst of these violent uprisings and protests, and he fled to save his life. And that was kind of the dominant narrative in the English-speaking press. We were very conscious when we filed this to create a different framework and a different narrative and really push this hard. And so we filed this, and we made sure that the Washington Post and the New York Times and the different kind of big outlets covered this. And all of a sudden, the narrative became, at minimum, not that he necessarily did it, but at minimum, this guy's been dragged into court for ordering the massacre of indigenous campesinos. And that changed things a lot for him. At the time, Goni was speaking at different universities, at conferences. I remember the year we filed, I was at Harvard at the time, and he did a talk at Harvard. I believe that might be the last talk he did at a university. He became a pariah in many ways. His neighbors knew that this guy is getting dragged into court for gunning down people, children as young as 5 years old. That's not a good look. So it was really helpful for shaming him. And it also served to shame folks in Bolivia and send a message in Bolivia. Look, the United States, unfortunately, is we have an open door policy. The number of dictators and generals and people who committed rights abuses, particularly in the Americas, and then fled to the U.S. like nothing happened, it's tragic. And, Bolivia is no exception. But this sent a message in Bolivia that if you kill people, we're going to go after you in the United States. And maybe we win, maybe we don't. But you're going to be litigating the next 5, 10, maybe 15 years. In our case, almost 20 years. You're not living free in the United States. So it really had an impact in Bolivia because we were very conscious of hitting this home over and over and over in the press in Bolivia. It had a real impact on that. And then the last goal we had outside of winning the case was more symbolic. And, I think it's one of the things that's sometimes overlooked. And I think in this case, it was the most powerful. Goni, he was seen as the face of colonialism in Bolivia. He really was. And this case was framed as we're putting colonialism on trial. And you can't underestimate how important it was for indigenous Aymara to be able to sit eye to eye with a man who was intocable, a person who treated them as second-class citizens, that would never have to be in the same room with indigenous Aymaras. And he had to sit eye to eye and listen to them tell their stories, point fingers at them, call him out for what he did. And he had to respond to them. That was transformative. I think sometimes lawyers, we like to romanticize the stuff we do and make these little things bigger. It was a big deal. It was a big deal for the family members. It was a big deal for Bolivia to make this man have to respond for what he did, regardless if we win or not. It had never been done, actually, in the U.S. And that the people at the kind of lowest rung in Bolivian society, unfortunately, had that opportunity was sincerely revolutionary. I think about, there's one of the plaintiffs, this man, Teofilo, his wife when the military came into the community, she was literally praying because she was so frightened. And they shot and killed her, and she was pregnant and lost the daughter. And Teofilo came up for a deposition, and we'd set it up so that, in the other room there would be real-time translation, and he'd be able to hear it. He said, no, I don't want to be there. I want to sit as close as possible to Goni so he can see me looking into his eyes. So he knew an Indian is looking at him and knows, and all of Bolivia is watching him and going to hold him accountable. And he told Goni, you are why my wife is dead. You are why I have no wife. And what that did for him, years and years and years of pain, that moment, that single moment transformed him like you couldn't believe. He went back, and again, I feel like I don't want to over-romanticize this, but he transformed. He wasn't a victim anymore. He was a hero. He went back to Bolivia as a hero, and he told this story over and over, and boy, it blew up in the press. I mean, they loved the idea that indigenous people get to hold this man accountable, say, we are watching you, we're not letting you get away with this anymore, was sincerely a revolutionary moment. And so I'm realizing how much over time I'm going. But I want to hammer this home that, boy, litigation can do really revolutionary things. And it certainly matters if you win. But in some ways, it really doesn't. If you set these things up, you can do really spectacular, creative things and move the needle if you are very intentional about how you litigate in all these different spaces, in the United States, in Bolivia, in international fora.
Great. And I have a lot of questions on that presentation, so I'm sure many of you do as well. And so thank you for that. And we'll go to Katie Gallagher.
Sure. Well, thank you. And that is amazing to hear. And we didn't even hear about the outcome of the civil case yet. So, yes, there's more. But I'm going to pick up some of the themes that Thomas talked about. I'll start just by saying a little bit about my organization, the Center for Constitutional Rights in New York, and how we work. So we were founded during the Civil Rights Movement, and we were really founded as a group of lawyers who are working in deep partnership with and in service to the civil rights movement in the United States. So we don't see ourselves as the leaders of movements for change, but really part and parcel of that movement in many ways, and a resource and a tool for movements who are looking to bring into effect the rights that are protected in the U.S. Constitution and the U.S. Declaration of Human Rights and various international human rights treaties. So we consider ourselves movement lawyers, many of us do, and the best work that we do is when it's really done in cooperation and partnership in service to movements, be it U.S.-based or international human rights movements. And that can be something like a group of plaintiffs who are seeking to push back on a corporation, like in Nigeria, or it can be on behalf of community organizers in New York who are calling out the New York Police Department for the stop and frisk program and the fact that it was unconstitutional. So the movements can look like very different things. There are occasions where, because of the nature of the pressure coming from the government or the powerful entity, there isn't yet a movement. There is an issue that's maybe hidden behind the surface. And one example of that is the work we did post 9/11, post September 11th, representing detainees in Guantanamo Bay before we even knew who the detainees were. There were certainly anti-war movements that we partnered with and anti-torture groups, but it was a very unusual situation when we started that work because there weren't yet the actual plaintiffs working with us because we didn't even know who they were. So we see, similarly to what Thomas said, we see the law and litigation as a tool, but it is not the only one. It's part of a toolbox, so you should have an advocacy agenda or understanding when you're bringing litigation. The cases I bring are also quite difficult to win, and I hope it's not because I'm a bad lawyer, but they can go on for a very long period of time, and they often don't end in success. So it really is important to, at the outset, as Thomas laid out, understand what you're trying to do here. Shift a narrative, empower a community, open up space for policy change, work with the media to bring attention to a problem or a group that thus far has really not gotten the attention or the understanding of what's happening, that through filing a case, you might be able to help with the reframing and the amplification of community organizers. So we see, again, we also, winning is a very nice thing. Winning in the courtroom is a good and it's a good end to go for, and it's certainly one that we do. Every case that we filed, we believe has strong legal merit, and we believe that if the law were enforced as the law is written, we would be successful. But we also understand that when you're bringing cases against some of the most powerful actors, be they government officials or corporations, you're facing an uphill battle because the law was largely written to protect them and their rights. And when you're representing marginalized community, vulnerable communities, survivors of mass atrocity, it's hard to be pushing back and expect that you're going to walk quickly to a court victory. So at CCR, we do have an expression, success without victory, and that's where you can shift narrative and really maybe create space for change in other ways than just the outcome of a lawsuit. So I'm going to very, very briefly talk about this set of work that we did and unfortunately continue to do in the aftermath of September 11th and the United States turning to policies and practices that were widely recognized to violate fundamental human rights norms, and particularly the absolute prohibition against torture. And so this is the George W. Bush administration time that I'm talking about. And at CCR, we do bring cases that are on behalf of communities outside the United States where the U.S. government isn't involved, but we usually have, for CCR, because we're pretty small and we can't take a lot of cases, we usually look to have some kind of connection to the U.S. So whether it's that the U.S. has become a safe haven or is facilitating a foreign torturer, for example, or a U.S. corporation is involved, that might be a reason why CCR brings a case. Or if there is a government where U.S. policy is really propping up and aiding and abetting violations, again, that's an area where CCR may bring a case. But this post 9/11 work was work that was really directly against the Bush administration and those in benefiting from the policies that really supported very concretely through torture memos the bending of the law to make what is clearly unlawful appear lawful. So as you may or may not remember in this room or have studied probably some of these cases, after September 11th, the United States set up Guantanamo Bay, a place that is once again in the news and where CCR is once again litigating because of migrants being sent there, literally litigating as we speak. At that point in time, after September 11th, the U.S. used it as a detention center for people that it was rounding up based on mere suspicion, largely based on identity, be it Muslim, be it Arab, be it Southeast Asian, picked up and sent to Guantanamo, where almost 800 people went through, and there still remain about 30 people there, held since right after 9/11. And that was one location and became sort of the most notorious. There were also CIA black sites set up, places that no one knew about. Jane did some very good work helping to identify where some of these locations were and the policies. And that was largely run through the CIA and through the military, but primarily the CIA. And then there were also other places, and this is what I'll talk a little bit more about, in Iraq. I don't know how many in the room have heard of Abu Ghraib prison. Is there anyone who hasn't heard of Abu Ghraib? And that's totally all right. It's now 20 years since the pictures of what happened at Abu Ghraib broke. But for many of us, I mean, those pictures are seared in our memory. Abu Ghraib was a prison in Iraq. And in 2003, the U.S. led an invasion of Iraq that ultimately turned into a multi-year occupation. And the idea of the U.S. invasion was regime change. A primary reason was regime change because of suspected weapons of mass destruction by the regime of Saddam Hussein, which it turns out were not there. And in response to the U.S. invasion and the toppling of Saddam, there ultimately was an insurrection back against the U.S. presence. And so in the summer of 2003 into 2004, with the rise of the insurrection, the U.S. started to do mass roundups in Iraq and ultimately detained tens of thousands of people. And some of those individuals were held in this prison known as Abu Ghraib. And Abu Ghraib had actually been a source of torture during the regime of Saddam Hussein. So this was, for an Iraqi, a place that just said torture before anyone knew what the United States was doing there. And in the spring of 2004, photos leaked of absolutely horrifying conduct carried out by U.S. military and others in Abu Ghraib prison. Pictures of naked Iraqi detainees with bags on their head, put in human pyramids, naked with dogs, threatening dogs. There was a lot of sexual violence, which again is work that you did a lot of to make well known. Naked detainees who were forced into sexually humiliating positions, threatened with dogs, a lot of use of females to further humiliate Iraqi detainees. So these photos came out in the spring of 2004, and again were quite shocking for all of us to know that this is what U.S. officials, U.S. Citizens had done. And it turns out that the military had been investigating what happened at Iraq. And in their report, they found that it was not only members of the military, but it was also private contractors. Because the U.S. had rushed into the war in Iraq and wasn't adequately resourced and prepared for what followed that invasion and the mass roundups that it was doing, it had to outsource certain functions, including interpretation services in prisons and interrogation services. So two companies, Titan and Khaki, were hired. And what the military found in the case of Abu Ghraib was that some of these private military contractors stepped into a command vacuum that existed. There wasn't proper oversight going on in Abu Ghraib. And in that space, where there had also been so much demonization of the Iraqi detainees, that the contractors who were serving as interrogators were giving orders or encouraging military police to quote unquote soften up detainees, i.e. to torture them, to subject them to severe physical or mental harm, including beatings, loud music, freezing cold temperatures, threats to themselves of sexual violence, threats against their wives, hearing the torture of other detainees, which is a form of serious mental harm when you hear this happening to someone else and worry it can happen to you. So the idea of this was to soften up detainees. So one of the people who was released from Abu Ghraib came to the United States. And he came to the United States actually in the months before these photos came out. And because CCR had been representing already the families of individuals held at Guantanamo Bay, and we were looking into the CIA black sites, we had already started a series of cases against senior U.S. officials, actually including using this same law, the Alien Tort Statute, the ATS, which is a law from 1789 that allows non-U.S. citizens to come into a federal district court and bring a civil action for a violation of the law of nations. And so because torture is globally prohibited, this is something that constitutes one of these law of nations violations. So we had brought the cases against senior U.S. officials for other places, and we're hitting up against walls. It's very hard to hold U.S. officials accountable, even though we have a criminal statute prohibiting torture, even though we're a signatory to the Convention Against Torture, even though in some of the ATS, Alien Tort Statute cases, against non-U.S. officials, federal courts have recognized that, yes, you can bring this action for torture. When it comes to U.S. officials, all kinds of defenses are raised. Maybe things you've learned about in constitutional law or federal courts, things like the political question doctrine, or foreign or sovereign immunity, or other kinds of preemption defenses, or state secrets. There were a range of defenses that made those cases against U.S. officials very difficult to bring. So when we were looking at this case of Abu Ghraib that came to us, we decided to bring it against the contractors. And I want to emphasize it wasn't only because the cases against U.S. officials were proving difficult. It was also because, and really primarily because of the responsibility of the contractors and this misunderstood or not well understood aspect of what was happening at Abu Ghraib. Like Thomas said, part of this is surfacing a narrative and understanding. So the wars in Iraq and Afghanistan were the most outsourced wars in U.S. history up until that point. And contractors were making tens of millions of dollars and were not being held accountable in the same way that the military who participated in the torture at Abu Ghraib, they were court-martialed because they're members of the military. The contractors working for a for-profit corporation hadn't been held accountable. So over the years, we filed multiple cases against these two contracting companies, Titan and Khaki. Titan ultimately changed its name to L3. We settled the case against them back in 2011. We lost the initial case filed on behalf of 256 people back in 2009 in the DC Circuit in a decision where the majority included Brett Kavanaugh and the dissent was Merrick Garland. So that was a difficult loss back in 2009. But the last case on behalf of 4 Iraqis actually went to trial this past spring, and a U.S. jury heard our clients testify. And similarly to what Thomas said, for our clients, 2 of whom testified via video link from Iraq, and 1 of whom came to the United States and testified in person in a courtroom in Virginia, being able to finally tell their story to a U.S. jury, that is part and parcel of why they brought this case 16 years ago. We've been litigating it for 16 years, up and down to the Fourth Circuit, 1 cert petition that was denied at the Supreme Court so far, but we made it to trial. And for them to be able to have that day in court and tell, say, this is the person who, not literally, but we were the anonymous, naked, hooded people who were treated as disposable. We are here, we are telling our story, and this is what happened to us. And especially for torture survivors, and it's definitely the case for the individuals in this case, it's also so that people know and it will never happen again. And so that was part of the message that they wanted to speak to a U.S. jury to understand this was done in your name, and it cannot happen again. So that case against the contractor is now up on appeal. We'll be briefing that this spring, but it raises some issues around corporate accountability. It raises questions about holding U.S. corporations accountable for things that happen outside the United States. Those are issues that, going back to this ecosystem that we operate in, it's fed a business and human rights corporate accountability movement. So it may be difficult at this point to hold corporations accountable in the United States, or more difficult than it was 15 years ago. But you now see inroads in other countries, particularly in Europe, where there's this boomerang effect. And like the U.S. official cases for torture at Guantanamo or CIA black sites, where we ultimately did hit walls holding U.S. officials accountable in U.S. courts, we brought those cases then under universal jurisdiction in France, in Germany, in Canada, in Switzerland, and ultimately were successful in getting the International Criminal Court to open an investigation into U.S. torture. So I think this ricochet effect between different places, bringing the cases, bringing them in partnership, thinking holistically. Do you use UN special procedures? How do you work with lawyers, human rights lawyers or advocates in other countries? Those are all things that are really, really important to success, and also the media. We had some different challenges than you had because for us, for our plaintiffs in Iraq especially, there were serious security concerns. So going back and talking in the media would have put a target on their backs, or could have put a target on their backs. Iraq, during many years of this litigation, was still in a state of war or great disturbance. And to know that you're suing, it can, in a U.S. court, it can raise suspicions. So sometimes as the lawyer, you have to do more media work than you might want, especially when you believe that it's the client's case, and empowerment of your client partners is what you would like to do. So just flagging that. And I just want to end. I know I've already, I also spoke too long. I think this history of what happened after September 11th is particularly important to look at right now in this moment. On Friday night, we had the new Secretary of Defense replace a number of military lawyers and say that he was doing so because they weren't sufficiently supportive of the warrior ethos. And he wants to kind of loosen the laws governing military conduct. Now, one of our strongest allies in all the post 9/11 work that I did around the torture program, the U.S. torture program, was actually from retired military, because military are on the front lines and look to the Geneva Conventions to protect themselves from this kind of treatment, be it torture or detention without charge. And so I think it is a moment to be a little bit concerned, at least a little bit. Certainly I'm more than a little bit concerned about statements like that, where we're lessening protections and adherence to international law. And I think there are some lessons to be learned from what we were successful at post 9/11, and also some unfortunate lessons where the courts abdicated their role to the executive and really trusted when national security or state secrets were invoked. I hope that at this point in time, the courts are looking to be stronger. And when there's a violation, that whether it's the political question or other defenses, are really looked at with serious scrutiny, and that the laws that have been put in place to protect fundamental human rights, including here at home, are given effect. So I'll stop there.
Thank you both for those extraordinary statements. I'd like to open the floor for questions. If you could just say your name and your year of school, and if you're JD or LM, that'd be really great. And then we'll go from there.
Hi, thank you for the presentation. It was very illuminating of many issues. My name is Alice. I'm an LLM from Brazil, and I'm in the Human Rights Clinic. And I have many questions, but I will just ask you one for now. So I was thinking, at any time in the process of both the litigations, have you considered bringing the case against the states themselves in international regional courts? For example, in Bolivia, bring it to the Inter-American Commission on Human Rights, or to the ICJ in the other case. Have you come across this situation?
Great. I might take one or two more questions if that's possible. So the question is essentially, how do we think about multiple venues in doing human rights litigation, including regional venues, including international venues, and maybe complements to domestic venues as well?
Hi, my name is Bettina. I'm an LLM student from Germany, and I'm also, like Alice, part of the International Human Rights Law Clinic. So my question is, so many of these cases usually involve a very lengthy litigation. So for those of us that would be interested in working in international human rights law, I would just like to know from your experience how you deal with that, because working on a case for over a decade, for 2 decades even, I can imagine that can become very, very tiring, very frustrating, especially when, yes, I know it's not just about winning, but at the end of the day, you still want to vindicate rigorous human rights violations of your clients. So I just would like to know how you deal with that, and if you have any tips for us.
Great. Any third question?
Hi, I'm Catherine. I'm a third-year student. JD, I guess, not LLM. I'm interested in sort of how you go about making decisions when you think that your advocate role is not super harmonious, maybe with like your legal advocate role. Whether it's like how to engage with media, or like whether to put a particular witness victim on the stand or something like that, and how you sort of are able to balance
Great. I think we'll take a pause. Sorry, do you want to add a question into the mix?
Sure.
Yeah.
I'm curious about
So introduce yourself to the group.
now like JDLM. With the ATS, it seems like courts have sort of limited its scope, but this seems to be the first time where it's been applied to sort of subcontractors and potentially broaden the scope for U.S. military. I'm curious, do you think this could have sort of a backside effect in the sense that if it broadens the scope too much, perhaps the U.S. will be sort of more interested in this and narrowing down the scope even further?
Great. How do you prefer to go, question by question, or what would you like to do? Okay, well, let me start with the interaction of the regional and the international institutions and venues and domestic spaces.
So, yes, we did consider the Inter-American system, the commission and the court. In a lot of the international spaces like this, in the regional spaces, you have to exhaust local remedies. So, and I think that there's value. Ideally, Ghani, the ex-president, you asked whether the outcome of the case. We won in the United States. It was a very special moment. It was spectacular. It would have been better if he was tried in Bolivia and held accountable in Bolivia. I think it would have had more impact. That would be ideal. So I think we want to start there. But, everyone has a different approach, so maybe my approach is not the best. I think that the way we've done this for a lot of years is, in many ways, throw it at the wall and see what sticks. We often try a lot of different approaches, and not that just like haphazardly, just kind of try everything, but being very conscious. Because the thing is, you may end up with a horrifically bad judge in one space, so you may want to lean into this one. And so I think we try different tactics and see what seems to be the most successful and lean into that and see the ways that they complement each other. As I mentioned, the trial in Bolivia and the civil suit in the United States, and we really use them in ways in tandem to basically bolster the other. And both, I think certainly the case in Bolivia would not have happened without our case, but the case in Bolivia, I don't think we would have won in the United States without the vast amount of information we were able to extract from the state in Bolivia through this lawsuit when we did or the criminal case we did in Bolivia. And we consciously tried to, we don't really we're limited in what we can decide, but we tried to kind of stagger them and do them at a pace where this case could actually really help the case of the civil suit in the United States. So certainly, the Inter-American system is something that I use a lot in other circumstances. In the case against Ghani and the Black October massacres, it was, we pressured the commission to pressure the Bolivian government to move forward on things, but we didn't bring a case because things were moving forward at a much slower pace than we wanted, but they were moving forward in these other spaces that I think would have made it impossible to bring a case in the commission. Or the court.
Sorry, before Katie jumps in, definitely in my experience as well, particularly when you're working on cases where you have a dearth of information, like you really do use multiple venues simultaneously to get information that you can use in other cases, right? And whether that be through, I've had examples of using litigation in Tanzania to bring a US case. You have to do that when you work in countries where the violations are transnational and where the governments are resisting giving you information. Right? So we often do think strategically about how to use different venues in that way.
Yeah, I can touch on this one and then bleed into the second question about length of time. But just to say, hearing who's in the room, the fact that you have JD and LLM students, you are incredibly lucky because you are right now building up your network so that when you need to look at two different venues, and maybe a case will have involve litigation in Brazil that has a U.S. connection. So you are really, we think of networking always as this very formal thing. You are building your partnerships right now. And so that's a lucky thing to have. With our work, we also have looked at very many bodies. The Inter-American Commission was the first place we went with Guantanamo Bay detainees and tried to get precautionary measures in place already. And that ended up dragging on for many, many years. And the United States doesn't give the same compliance to decisions out of the Inter-American Commission that other places do, unfortunately. It's sometimes, depending on the administration, it may lean in a little bit more, and then at other administrations, it really just backs off. So you have to sort of, again, as has already been said, know why you're going to a venue. You can get a hearing You can have a client testify. There can be very powerful advocacy opportunities in some of the regional bodies, even if you're not getting the binding decision. Now, those cases that looked at the complicity of European states with the U.S. torture program and went to the European Court, there are very, very clear, strong, factually detailed, and enforced judgments that have ended up having some impact back here in the United States. The International Court of Justice for the United States is a hard one because the U.S. has really withdrawn itself from much of it. But there is a case right now pending that has had an impact, or had a relationship, I should say, with one of the cases that I recently did. And this is one that moved much faster than the 16 years. And that's a case that we filed in November 2023 against then President Biden, Secretary of State Blinken, and Secretary of Defense Austin on behalf of Palestinian organizations and Palestinian Americans and Palestinians in Gaza. In that case, Defense for Children International v. Biden was filed 1 month into what we were seeing happen in Gaza, where there were already risks that what we were seeing was an unfolding genocide. And the Genocide Convention has a duty to prevent requirement. And so we filed a case for the failure of the Biden administration to abide by its duty to prevent, which requires a government to take positive action to not further that risk. So continuing to send weapons was something that we said undermines the duty to prevent. And we also had a second claim that was aiding and abetting genocide. And we said it could be this, and it could easily bleed into that and be both. And so we filed that case in November 2023. In December 2023, South Africa filed a case against Israel. We ended up also seeking in that case a preliminary injunction. So unlike the cases that we've talked about that were brought under the Alien Tort Statute for damages, this was seeking an injunction to get a bar on the further provision of weapons to Israel by the Biden administration. So because we were seeking a preliminary injunction, the case moved so fast. We filed in November, briefed in December, and had a hearing in January. And it was a hearing where a preliminary injunction, you have to show that there are sufficient facts. The judge in California allowed us to have a hearing where our clients testified. So we actually had a doctor testifying from the hospital in Gaza, in Rafah, in real time through a video link. We had the head of Defense for Children International Palestine testifying in a courtroom in California from Ramallah. And then we had Palestinians in the courtroom testifying using words that had really never been said in a U.S. courtroom, like Nakba, like ethnic cleansing, and talking the names of their family members and villages. And so that was a case that was the opposite, where it moved very, very quickly. And the day of our hearing was the day that the first set of provisional measures came out from the ICJ. So while it was not a case against U.S. officials at the ICJ, the interrelationship between these two cases, what we filed in our complaint, which was 85 pages, and what South Africa filed, you'll see many similarities there. We weren't working directly with them. So that case, ultimately, we did lose it. Again, holding U.S. officials is very difficult, and we lost it under the political question doctrine. But I think it helped in terms of a narrative. And I, in some ways, I find the loss of that case, which moved very quickly, emotionally very difficult compared to a case that's taken 16 years, which, yes, is very tiring. And very difficult also to call up the clients after 4 years, where it's all been briefs up and down to the Court of Appeals, and then call and say, okay, now get ready for a deposition, and let's talk about that torture that happened to you 15 years ago, and bring things up again. That can be very difficult. But as long as the clients want to continue, and that they see a value in keeping with the fight, I think for me that's the North Star of where you get your your energy from. And when you see that we went to trial in Abu Ghraib 20 years after those photos were leaked, and now we're up on appeal where the idea of contractors and contractor liability will be again at issue at a moment when we're seeing a shrinking of the government and some privatization that will be coming. Some of the issues take on new and different lives and very relevant lives in cases too. So yeah, it can be difficult to do these long cases, but I think it goes back to what I said at the very start of how we work. When you work in very deep trust and partnership, you also know then when your partners say, look, at this point, the fight is done. You know, in the courtroom, the fight is done. We need to move on or we'll take it somewhere else.
So we had two more questions. One about essentially if and when there are conflicts between a legal role and obligations and your hat as an advocate, how do you reconcile those potential tensions? And also the question about the backlash potentially from various ATS approaches.
So maybe I'll take the first one. And actually, I may say something about the one that she just answered briefly
yes,
in
please,
terms of, because I think you mentioned this early on, is, you know, I also identify as a movement lawyer. I think you need to put your clients, the plaintiffs, the movements, they're in the driver's seat. And I think, boy, it sucks to litigate 20 years. It really is brutal. Imagine having to share the story of your child being shot in front of you over and over and being accused of being a terrorist and a narco trafficker or a communist, whatever. It's litigation.
Enemy combatant.
Yeah, I mean, it's not fun. It's horrible. And I think that, you know, I have some critiques of a lot of, you know, I think often in law school, students want to litigate more than they probably should. And I think that a lot of litigators just come in, and it's very paternalistic. It's like, in some ways, it can be set up in a way where the lawyers do everything. And, you know, the social movements or the individuals that were impacted just play this secondary role. And I think when that happens, 20 years or 15 years, 12 years, whatever, it becomes really hard. But if they're in the driver's seat and they're engaged and they have agency in this, they're committed. They feel this. They are empowered by this process. And if you find these kind of micro victories along the way, or many not even micro victories, other victories along the ways, other ways that you can use advocacy, I think that 12 years, 15 years becomes, again, it's very challenging. I don't want to downplay it, but I think it can be dreadfully hard, or you can use this in a really powerful way that I think empowers communities that have been impacted. And as for the role of, you know, a lawyer, well, I wear all the hats, and I struggle with that at times. You know, I could mention this in 30 different cases I've worked on, but I'll talk about the Bolivian one in particular. The defense of the president was that poor me, I was being overthrown by a bunch of Marxist guerrillas, and Thomas is convinced these indigenous people that, you know, Thomas the communist was trying to take me down. I mean, to simplify it, but that's really what it was. And so I had this lawyer role where I had to, you know, this is not about politics. This is about the law. It wasn't just about the law. This is about this guy. You know, I said it. We framed this in many ways. We were putting colonialism on trial. This guy represented an entire system that treated indigenous people like slaves, that killed so many more people than these individuals in this case. And we were very intentional. You know, there's a conflict at times between what you want to present in the courtroom. And sometimes you know, there's this tendency to have the most sanitized version, have these kind of, you know, perfect victims. And we chose actively not to do that in this. We knew that we were taking risks. We knew that this could complicate this. We wanted to show the blemishes because we wanted the families to not be victims. We wanted to give them agency. We wanted to show this because at the end of the day, unfortunately, you know, often what happens in the courtroom, that becomes the narrative. And we were really concerned that if we sanitize this and it was poor victims against a big bad guy who shot them, we were worried about the impact that would have for larger social change following the case. So we put the blemishes out there. We gave them agency. We mentioned things like protesters were destroying things. Miners were using dynamite in nonviolent ways. It was a symbolic thing in Bolivia, but we were not going to hide these pieces. We wanted to show this is what it is. And so there was this tension. We complicated our trial by doing this. And I went out on the news and I fed into their narrative. I didn't just say this is about poor victims. I was very upfront. often what we try to do, in other cases, I think we try to divide roles where there's the advocacy side and then the lawyers so that it's a little cleaner. This was, again, I was a 1L when I started a case, figuring it out as we went. And there was a much bigger team. CCR was on the case with us. I mean, this was not, I don't want to say it was just like me and some, my campesino friends. We were figuring it out in many ways, but we had a lot of infrastructure and support. But, we were just kind of going with the flow in some ways. And I think one of the things I've learned from this is how to kind of wear those different hats and if we can divide them up so that beyond even, like I was asked to write a book on this early on. And, when you do too much of the advocacy role, boy, that opens up a lot of discovery can become a problem if I'm writing books on this so I think we try to divide these roles when we can, but sometimes you don't have that. I mean, we work for nonprofits and we're working for communities that don't have resources. Sometimes we just got to do it all, unfortunately. And I think you got to figure out how to divide that up. There's no clear answer. Sorry. It's just, I guess it depends on each circumstance.
Yeah. And I would just say, I think to try and be as intentional with the decision that you're making so that you don't walk yourself into a problem. And that includes having a clear understanding of the why of the case with your clients. And at the end of the day, your job is, if you are the litigator on this case, that's where you also have the responsibility to raise the potential hazards or risks, and then the decision can be taken. So, there could be points in time over a long litigation where you're more careful than others, or I shouldn't even say more careful, more quiet. Mm-hmm. And that's intentional because the cases ebb and flow. But don't be surprised if a news media clip is shown at your trial of your client 14 years ago, which happened in our case, where, as our client was saying, it's very difficult to talk about torture, which it is. The other side showed a video clip of him on a media, on a news show. And I'm guessing that it appears that the idea was, look, he's out there all the time talking about this. There aren't many media clips you would find, but it was something that they tried, and apparently it didn't work with the jury. So I think the trying to be as intentional as you can be, which some of us have learned as we go, and I put myself in that box too. So the more you could just think ahead. And I'll just hit lastly on Malik's question of the narrowing of the ATS. This case that I talked about that went to trial, actually we went to trial twice because there was a mistrial the first time, or a hung jury. We filed in 2008. The Alien Tort Statute has been at the Supreme Court an additional 3 times at least since Kiobel, Jesner, and Nestle. The ATS is a statute from 1789. It had never been before the Supreme Court until 2004 in the Sosa case. This statute hadn't really been used in the way that it is being used now to advance human rights cases until 1980 in the Flartica case. But it went its first 24 years without any Supreme Court review. And now we've had the Kiobel decision in 2013, the Jesner decision in 2018, and the Nestle decision in, 2021, 2022. And there's a cert petition pending right now on the ATS again. And so where these cases came from, it wasn't so much about going against U.S. officials as really going against corporations. And the question of corporate accountability and can corporations be sued? If so, which kinds of corporations, U.S. or foreign, which frankly in 2025, that distinction is pretty hard to draw when you're talking about multinational corporations. And what is the kind of conduct that they can be held accountable for, and where does it have to take place? These are the questions that the Supreme Court has taken again and again, and what we've seen is a narrowing and narrowing and narrowing of the kinds of cases that can be brought before the federal courts. And Congress, in its last term, during the Biden administration, actually looked at expanding the ATS to give it a broader life. So I'm not sure that it's going to be narrowed by Congress at this point, but let's see what happens at the courts. And if it is narrow, then we have to look at other places like state courts or state laws. You don't have to call something a human rights case for it to involve human rights. Look at cases around forced labor.
I'm going to stop you on that exact point, just because of the timing. So sorry, because we can't go over. And it's a great place to end, which is that we constantly reinvent the spaces in which we seek redress, and we don't always use a frame of human rights to do so. And sorry to cut you off, Katie.
No. You're seeing the clock.
Thank you, everyone. Thank you to our panelists, first of all, and thank you again to our students for exceptional questions as well. And please join me in thanking.
No.
Thank you. Let me ask you.
I do think that's a nice way to end there.
Yeah,
Constantly
reinventing.
This is the...
Yeah, I think we are still. I don't know how to.
By the way, the Biden case, because I've been working...
So you know you're still being recorded.
Oh, yeah. I'm not going to say anything delicate on this other than I do think it had an impact. I mean, we've been doing a lot of work on Palestine as well. Certainly.
It's up now.
Yeah. No, it's I can't. I actually know how to turn off the video. I don't know how to turn it off. Are you going to a career session? Is it now?
Yes.
Do you know how to turn off the recording? Do you know how to turn the recording off?
How to what?
Turn off the recording. Sorry, thanks, one.
Oh, it's on. It's on? It's off. Bunny, it's off.
Cut off.
Not necessarily.
So I thought it was going live right now.
Should have been at 30 days. But yeah, I got it.
So we had 9 on the live stream.
Hi. Do you have like 2 seconds? Sure.
I can grab it. I can. You don't need to walk all the way over there. It's all good. I'm heading that way anyway.
I'm sorry, he was into that.
Are you heading to the live?
Yeah.
Thank you first.
Thank you. Thank you. This is wonderful.
I'm good. How about you?
Thank you. Well, we'll be in touch. I'm really happy to see you every
I knew y'all were going to be fun, but I didn't realize it was going to be that day.
I just want to say how good this is. I wanted to challenge you if it's hard for you.
Yeah, I do have a card. Sure, I can give you.
I'm just appreciate
Do you need a spoon? Off the charts. And like they just come in waves. For some reason, I'm getting like another round. I think this will be elections this year. And after the coup stuff, I took way more hits than fixing cases. So, sorry if there's trolls.
Yeah. Thank you.
Twitter's
Ever feel like
there.
if it doesn't matter overall,
Yeah, the Vatican piece, I think even though we lost it, it's heartbreaking loss. I think it was still an important piece to bring. I think for us, for our clients who are feeling, so this is how we've been so devastated at that moment. And the discussion and debate in November 2023 was all about proportionality, self-defense, and then coming in with the genocide thing that was deeply grounded in law, I think helped in terms of narrative and opening up space. And has fed other things, including the South African case.
And honestly, the law, like those legal arguments about disproportionality. I mean, in my opinion, the presence she used.
You're right, and that's why we said we're not even debating on that field. We're going to move it over here, and we're going to talk about genocide because when you're denying access to food, electricity, and everything, that's So yes and no is the answer. I think it was critical that we brought the case. I'm so glad we brought the case. I'm very sorry that we lost the case, but I think it was important to bring in. The fight continues.
Yes,
and then we will continue this fight ourselves elsewhere too. Through law.
Yes.
Okay.
Okay.
Thank you for the comment.
Thank you.